Supabase has been banned in India. Hi guys, this is Sanket here
And this is Vipul.
and welcome to the podcast of Comply DP. We want to bring to your attention a few hours ago, Supabase has been banned in India. According to the government official, they have said that some data was shared which shouldn't have been shared. So, Vipul, what do you think? Why has it happened? And what should we think this about in terms of DPDP as well?
Yeah, although a detailed response is yet to be coming from the side of the government, and when we look at from the perspective of DPDP, this is an indicator what lies in the future, and it also gives us an opportunity to assess our own preparedness and what kind of impact such bans can have on our operations, especially for SaaS or any fintech or any regulated tech companies in India.
Right. So let's inform our viewers under what section of the Act and which Act this issue of a particular ban has been placed. So please tell me what section is it?
So this is first of all, the Act is Information Technology Act, and the section under which it has been banned is 69A. I'll just read the heading,
Definitely.
which says that power to issue directions for blocking for public access of any information through any computer resource.
Right. So, first of all, we'll let you know there has been no particular direction or circular which mentions why it has been caused. But when asked through officials, it was mentioned that there was breach of the purpose of data which it was meant for. It was shared for other purposes as well, which the government is frowning upon and does not allow.
Okay.
So let's talk to let's coming to the point. Let's talk how this is a precursor to the DPDP Act.
So first of all, we should try uh, understanding what this ban means. Practically, I think more than 80-90% of the founders in the SaaS industry, or even if they're building consumer tech or any fintech or any regulatory tech, the go-to option for all the founders today is Supabase across world, not just India.
That's right.
And that's the reason why Supabase has grown multifold, and it has been the real beneficiaries of this AI revolution.
Right. So let's elucidate further for the audience.
Correct.
So Supabase actually is a backend software application where you can store your data, right? If I'm right.
Correct.
Yeah, and it runs on a SQL query.
It's primarily uses Postgres,
Yeah.
and it is memory as a service. You can understand it like
Right.
that. And now we'll come back to the DPDP aspect.
Definitely.
What pointers it is providing us, and it's a chain of events which has taken place in the past. Earlier, we have also seen that WhatsApp was put a strong fine
Yeah,
of
around
213 crore.
213 crores, and that was issued by the Chief Justice of India. So
Correct.
it's a kind of a make or break situation, like if you would have seen our previous videos.
Yeah, and with a strong warning by CJI, the Honorable CJI has stated that if you want to stay in India, you have to comply with rules and regulations and acts of India and Indian Constitution.
That's correct. So we would also, want to let everyone know if they've been thinking, oh, I'll get DPDP done later when the deadline comes, and nothing of structure has come to it. So I think you're highly mistaken at this point.
Yeah, so what kind of preparedness we can begin even from today is that we should keep our breach response ready,
Right.
so that government need not take such harsh steps against any enterprise,
Right.
because all the services gets affected, the company loses the trust of the consumers or its users. So for example, the first provision which comes to mind as per DPDP is within 72 hours the company, in this case Supabase, should have intimated to the users whose data has been breached, that is data principals,
Right.
and also informed the same to the DP board.
Right. So again, let's explain our users what data principal and data fiduciary is, because some of those guys or some of our viewers would be watching for the first time.
Correct.
So a data principal is any person who is from India, is a citizen of India, and a data fiduciary is a company or any website who takes the data of a data principal, right?
Right.
So now we come into the point that any data fiduciary who has to take data of any Indian citizen, they will have to comply with the Digital Personal Data Protection Act of 2023 and rules, which whose guidelines and intimation has been issued via circular by 13 November 2025.
Yeah. So another aspect is that first of all, the organization should utilize this an eye-opening moment, uh, trying to assess where their data is going, because when we sit with a lot of CTOs or compliance officers, till now they don't exactly know which data is being shared to the third party. So this is an opportunity to create an probably a sprint in your organization to assess and chart and map out where which data is going, whether it is masked, whether it is vaulted or not. All those processes are in place or not.
Right, definitely. So at this point of time, any company should start looking inwards, because this is just not a legal compliance. It is a techno-legal application, and at every point, at every level, one has to carefully tread to understand whether they are following the principles of the DPDP Act as well.
Correct. And the company should also assess whether they are in a position to delete, update the data of the data principals
Right.
or the users, and with the same ease through which they have taken the consent.
Right.
So,
So,
yeah,
yeah,
go
so
ahead.
Vipul, don't you think such a particular act by the government of India is clearly issuing a statement that you can't affect our citizens' personal data, and it is actually, affecting in a way the sovereignty of India as well?
Correct. So privacy has been many a times affirmed by Honorable Supreme Court that it's part of the fundamental right. So if that's not getting safeguarded, and if there are not proper mechanism to safeguard that, then definitely it's an attack on the sovereignty per se as well.
So if you're collecting any personal data, we would just like to let you know the cost of preparation is predictable, but the cost of enforcement isn't. So we should actually, start to take any readiness assessment, shouldn't we?
Correct. So the Act states that the maximum fine that can be imposed is in tune of 250 CR, especially for significant data fiduciaries. But even for non-SDFs, it can go as high as 200 crores. And it's just not a one-time penalty, but for every mistake or every violation for DPDP Act would invoke a penalty of such huge amount every time.
So each incident creates a specific penalty here. It's not that you have, broken the law and you'll be just charged one time.
It's a make and break
It's a make
situation
and break
for
situation.
majority of the companies,
Exactly.
right?
So we would definitely want to help each company out in case if they think they want to have a early assessment of their DPDP readiness, just to know where they actually stand right now, where their data vendors are processing the data, how they're processing the data, or how their data is being transferred into cross-border areas and how it is being used, right?
Yeah, and also the first step any organization at this time can start by creating a budgetary allocation for implementation of the DPDP Act, because
Right.
majority of the companies with whom we are in conversation about DPDP implementation, they have not yet created budget, and
Right.
it's a very opportune time. The April is coming just in a month, and the company should start preparing. uh, the the compliance officers should start contacting CFOs or
Definitely.
legal heads. They should start bringing their attention to the fact that it will require resources both in terms of time and money for implementation. Whether you have to create a team inside which will consist of legal and technological people, or whether you outsource, whatever works.
Yeah, so Vipul, don't you think we have had a discussion with a lot of CTOs, a lot of founders, even listed companies, compliance officers, even fortune companies in India, they have not started the process in itself, and it is a worrying situation, isn't it?
Yeah, many are believing that it would be like any other law by government, would be extended and more time would be uh, awarded for its implementation. But government, on the other hand, is only trying to shorten the hard deadline by making it 12 months, which was initially 18 months. Although institutions like IAMAI are asking that the government should consider that this small amount of time would not be sufficient for its implementation.
So I think in the foreseeable future, government doesn't seem to be uh, elongating any part of the deadline. So it is the onus is on the companies now to actually comply or back up, as the Chief Justice, Honorable Chief Justice of India has mentioned, that either comply with the rules of India or leave the country.
Yeah, and recently we also had a discussion with one of the RBI functionary. He was suggesting that what he is communicating to the corporate sector is that they should start doing it themselves without any outside help.
Right. So we'll wrap up about today's incident and just putting you under the intimation that please start preparing for the DPDP readiness. And if you need any help with that, you can definitely book a Calendly half an hour interaction where we can actually help you with a initial gap readiness assessment. And in case, you can definitely contact us and you can connect us with privacy@complydp.com or even sanket@complydp.com, and we'll be there to help you.
Yeah,
So thank you for your time. Hope to see you next time.
thank you.